1.3, the judiciary, dual systems of law. One of the more confusing facets of the United States legal system is the simultaneous existence of two entirely distinct types of law that coexist in each of two separate spheres of authority. Statutory law, the codes enacted by legislatures, and common law, that made by judges, are features of both in the federal and state systems of laws. How do these kinds and regimes of law interact with one another? State law. The power of state legislatures to enact laws must yield to the co-equal rights of other states and the supremacy of the federal government. With respect to other states, each legislature is expected to keep its law to itself. New York has no authority to tell dairy farmers in Vermont how to produce milk. Nevertheless, one state's legislation can seriously intrude on the affairs of another without overtly appearing to do so. For example, if New York taxes all Vermont milk entering New York so as to make it unprofitable, the effect on Vermont dairy farmers will be both significant and direct. In such a case, provisions of the federal Constitution come into play to prevent states from legislating warfare with one another. The Commerce Clause has been interpreted to demand economic fair play among states. The Privileges and Immunities Clause, superscript 4, which is Article 4, Section 2, protects various rights out of state residents. And the Full Faith and Credit Clause, superscript 5, which is Article 4, Section 1, ensures that a judgment rendered by one state's courts may be enforced in any other state, regardless of whether the other state has different legal policies. Federalist issues such as these are often delicate but rarely easy. It can be tough to tell whether one state has enacted regulations in order to meddle deliberately in another state's interest, or simply to protect the health and well-being of its own citizens. State laws are always subject to the terms of both the state and federal constitutions. These two overarching documents act as super statutes. If a state law is found to conflict with either, it gets bumped. Federal laws need only satisfy the federal version. Now, who decides what's constitutionally acceptable and what's not? Marbury versus Madison. Superscript 6 is 1 Cranch 137, back to the text, gave this responsibility to the courts in 1803. That decision was not based on any requirement of the Constitution itself, which says nothing about the issue. Responsibility for assessing the constitutionality of a law could just be as easily have fallen to state legislatures or perhaps to the governors, but Chief Justice John Marshall considered judges best qualified to determine whether a statute nudges the constitutional boundaries too strongly, and the rule remains to this day.